Well, I guess we should start, ladies and gentlemen. And before doing so, I will introduce those panel members who have not already been introduced, and I will do so in the order in which they're going to be speaking on the panel. First of all, Jim Pitblado, who is on my immediate left. Jim is a very well-known member of the investment community. He is presently, as I think your brochure indicates, chairman of the board of Dominion Securities Ames, one of the very large integrated firms in the business. He was born in Winnipeg. He went to the University of Manitoba and the Wharton School in Pennsylvania. He's been a member of the Board of Governors of the Toronto Stock Exchange, a member of the Board of Directors of the Investment Dealers Association, and national chairman of the IDA. A very with-it kind of person, as those of us who have participated with him in meetings can tell you, and I'm sure you'll enjoy him. Gar Emerson, who's on my immediate right, has already been introduced. He will be dealing with one of the areas the panel is going to deal with immediately after Jim. David Jackson will follow Gar. David is a partner at the Blake, Castles and Graydon firm. He is, I'm sure, well known to many of you. He practices primarily in the corporate and securities law area. He also has been involved with the bar admission course here and lectured at Osgoode Hall Law School, has acted as counsel to the stock exchange in the development and implementation of its markets in options and financial futures contracts, which is part of the smorgasbord of innovative alternatives in the financing area, which has developed in the last few years. Following David will be Stan Beck, from whom you will hear tomorrow, and I'm sure many people are aware of who Stan Beck is. He is, as you know, Dean and Professor of Law at Osgoode Hall Law School. He is a temporary member of, that's the Royal Commissioner of the Ontario Securities Commission. I guess the adjective is wrongly chosen. He is a commissioner of the Ontario Securities Commission. God help me. He practiced in Vancouver for a while before he entered the academic area, and is probably best known to those of us who haven't gone to Osgoode for his many seminal articles in the corporate law area, including the one that I mentioned in my paper, which is the quickening fiduciary obligation area as a result of the commentaries on Canero. And I guess the last area to be dealt with in the panel I will deal with. Now, we thought that flowing naturally from Peter Day's excellent review of the innovative areas in financing would be a discussion of corporate finance from the standpoint of someone who has been engaged in it, from the public financing standpoint, from the standpoint of advising boards of directors in connection with rather complicated mergers and amalgamations and major takeover bids. Indeed, one of the questions that was set up as a result of allusions that were made this morning to the role of the underwriter was just what is the lore in this area and what kind of services do these people perform, and how do they interrelate to the role of the lawyer in these complicated transactions, where the professionals that really are assisting the board and assisting the corporation are the underwriters, the corporate finance people, the lawyers, and in many cases today, because of the critical importance of the financial implications of so many of these transactions, the chartered accountants who are part of the working group. So Jim, why don't you take it from there?
Thanks very much, Gordon. You may need more than God on your side before we're done here. Let me deal with that in two areas, as you've indicated. One is in the area of new issues of securities, and I couldn't help as I sat and listened to Peter that his very lucid explanation of a number of these, of the new wrinkles that have been developed. It sure sounded awful easy, but let me tell you, when we were going through it as underwriters and had our capital on the line, there were some trying and difficult moments And I can think of one issue where from the time we bought the securities until 5 days later, the price of the stock against which they were priced was down 22%. They're interesting times. I guess in terms of the underwriter's role in new securities issues, I start from the premise of know your client, the old know your client rule. Who is your client? Company A. You want to know as much as you can about him. You want to know what business he's in. You want to understand his operations. Who are his competitors? What's his operating record been? What are his financial statements? Important for a couple of reasons. One, you're going to participate in the preparation of that prospectus, and we, as signatories to that prospectus, have legal liability for full, true, and plain disclosure. And secondly, it's going to be helpful to you in designing a covenant pattern if you're issuing debt securities, in designing your preferred share provisions, and also, obviously, in representing that client to the marketplace when it comes time to sell the securities. You go from there to normally working with that client on the development of his financing plans, what his requirements are, looking out a year or two. You try and develop a program, a financing program that may or may not be fulfilled depending upon market conditions. You'd move from there to design a specific financing package, be it a conventional debt issue, which aren't very much in vogue these days, or some of the more exotic packages that Peter has alluded to. If you are dealing with debt securities, you'd be involved in the development of the covenant pattern. If there is not a previously existing covenant pattern, security package. You obviously are involved in the preparation of the prospectus, which is that full, true, and plain disclosure document that we all know about. Through that process, you're also doing due diligence. It's part of the process of writing that package, but to participate in it is to fulfill in part your due diligence function, which has become, I think, increasingly more important to all of the practitioners as the state of the art has developed. Finally, you're involved in the marketing of the issue, the forming of the groups of securities dealers that are going to underwrite and distribute that issue to the Canadian public, so that you have then transcended, if you will, from an advisor into a liability position with your client in the purchase of the securities and the subsequent distribution of them to the public. So that the role encompasses, I think, a very broad role from knowledge to begin with of the client, to an understanding, to recommendations, to the jointly coming up with the securities plan, preparation of documentation, and ultimately to a specific transaction and an underwriting and distribution. Second aspect, very briefly, is the area of takeovers, amalgamations, and mergers. Gordon has given you a very apt description on a highlight basis. I have been fortunate to read his paper. It's extremely well done, and for those of you who are interested, I recommend it highly to you. Again, we're heavily involved as investment dealers, usually from the opening gambit. We're called in because it's been my experience when trouble comes, it's amazing how the management and the lawyers and everybody else all seems to hide, and there's one guy hung out to dry, and that's usually the investment dealer, because management are very well counseled by their legal advisor as to their liabilities. And I think we found in Canada basically that the courts and even the Securities Commission has been effective possibly as a delaying tactic, but it is not a deal stopper. And in the end analysis, my experience is that they all look at one guy. These things tend to happen on Friday nights. Gordon didn't tell you that because you got a 10-day period, and if it's on Friday nights, you can do it so that you can't get your hands on the circular until Monday morning. That certainly happened to us in the first city. So all of a sudden, out of your 10 days, you're left with 7. But you've got to, you're involved in the analysis of whatever the offer is. You're involved in evaluation of whether that offer, in your opinion, is fair from a financial point of view. The boards of directors are going to meet. The management is going to meet. You're giving your opinions to management. You're giving your opinions to the board. Again, when you look back and you read these decisions as to what happened, when you're in the pressure cooker of that 10 days, it becomes 7 and even shorter in some cases. There's a lot to be done. And we are under intense pressure to mobilize opinions, ultimately to write fairness opinions or opinions on adequacy, to put them into circulars. And while we don't have necessarily the same legal liability as we would in signing a prospectus, I think that we are very concerned that we have done our best to provide as representative an opinion as we can. We're obviously involved in unfriendly takeovers, in the white knight approach, in seeking to find somebody who's more compatible, in seeking to find another partner. And again, we're working very closely with your profession in particular, because these border lines and these boundaries as between the two get very blurred. So it's very much a cooperative effort. But we as investment dealers are very heavily involved in that aspect of activities.
Well, that's excellent. The 10 days that Jim was referring to is the period of time within which the directors are to respond to the bid. And of course, as I mentioned, it's critical to their assessment of the fairness of the bid that they get rather important advice from their investment dealer. Now, one of the other things that Jim alluded to was the question of due diligence. We see it now in the takeover bid area because of the imposition of statutory liability as a result of 127. 126, which is the statutory liability provision relating to prospectuses, is of course a great specter that hangs over the preparation of those documents. Prospectuses have been likened to get-out-of-jail-card-free documents. They are documents which require a great deal of care and attention. But recently, something has happened, something dramatic has happened, and I suppose that this again flows naturally from the developments to which Peter Day was alluding, and that is where you've got volatile financial markets and the window for possible financings open and close with a great deal of rapidity and regularity. It's important for financiers, for issuers to move into the market very quickly. Now, as you probably know, there are some roadblocks in the way in connection with public financings, and that is the time it takes to clear a prospectus through the Securities Commission. In the United States, there have been moves to shorten the period of time, and for seasoned reporting issuers, indeed, to provide either cursory or no review of the documents. In fact, about a week ago in the United States, Rule 415 came in, so that if we were acting for a Canadian issuer that was listed on the New York Stock Exchange and the American Stock Exchange and wanted to access the American capital markets, why there's a whole new set of rules. Well, we in Canada, confronted with the same kind of phenomenon, have been taking some steps too, and I think we thought that it would be important for you to understand what's happening, because there hasn't been anything published on the matter. And I guess the area that Gar Emerson is now going to deal with, you could briefly call toward a more responsive securities regulatory system.
What Gordon is referring to arises out of some of the problems that he alluded to, and that is this, that where the markets are active, and they're certainly not at this time, but when the markets were active and a number of issuers were coming to market with prospectus-type documents, there were a number of problems that arose. One of the problems that has been current, which has helped move this really old idea along, is basically the problem that many issuers found of the system itself, namely the 10 provincial securities commissions, to efficiently and promptly clear a full prospectus filing. Now, this problem of clearing the prospectus through the system was evidenced by the statement of the Ontario Securities Commission that it could not operate within National Policy Number 1 which I think most of you may be aware of. In that case, they in effect doubled the comment period from 10 business days for the first set to 20 business days, and then to an additional 10 days for comments from other provinces. Now, on the other hand, as has been mentioned a couple of times, large publicly followed corporate issuers have a problem if they can't come to market within a reasonable period of time. So, during some of the last issues, it was not uncommon for there to be a 7-week period from the date of the filing of the preliminary prospectus until they were able to market the issue. And this is especially critical where the markets are changing so much, because if a decision is made to do a financing and a financing window is seen, you simply can't wait for 7 weeks in order to offer the securities. This has resulted in some issuers filing preliminary prospectuses on speculation, simply hoping that during the period before the preliminary prospectus becomes stale, that a financing opportunity will come up. Now, against this background, there's always been an idea, I think, that as the disclosure system develops, one wonders what the use is of a 40 to 70 page technical prospectus where a large corporate issuer is offering additional securities into the public market. The question to some extent is that if there is adequate disclosure in the marketplace to permit the public to trade the listed securities of that issuer through the Toronto Stock Exchange, is there a clear rationale and a clear benefit over cost to require a much greater degree of disclosure concerning that issuer where it's simply offering additional securities through an underwriter? This has led to the conclusion a little bit on a theoretical basis that there is a great deal of questioning whether or not much of the disclosure that is in a prospectus is not in effect redundant and totally repetitive of much of the material that is already in the marketplace. Last summer, the SEC moved forward on this kind of thinking and proposed a wholesale revision to their registration forms along the lines that the offering document itself would integrate the information that already is into the market through the continuous disclosure system for reporting issuers with the information that is necessary in the context of a special distribution, basically on a consideration that there is no fundamental need to reproduce the basic information already in the marketplace. The offering document itself would then only provide information specifically about the securities that are then being offered, including the use of proceeds and other matters, and at the same time would incorporate by reference all of the other issuer-orientated material already on the public file. Now, to the extent that any of that material may be outdated or that there are additional material facts to disclose, then the offering memorandum would pick up those additional facts. Now, there have been, and I find this kind of a proposal or thrust a very exciting change for certain large seasoned issuers to achieve. There have been discussions among the provincial securities administrators to achieve this result, to attempt on a national basis to amend the prospectus forms for this certain category of issuer. During February, the Commission des valeurs mobilières de Quebec issued its notice concerning short-form prospectuses. And adopting the kind of theory that I have referred to, they have a proposal that will be discussed in May at the national meeting of the Canadian Securities Administrators, which basically provides that where you have a reporting issuer that has been within the disclosure system for 3 years, and where that company has a public float of $75 million, then it can incorporate its permanent information record into its offering circular and proceed immediately to market. The concept is, in this case, that the Commission would think that the offering circular would only be a 4- or 5-page document, simply relating to the transaction itself. One of the interesting things that comes back, and maybe Jim can comment on this, and Gordon as well, or others, is that in such a kind of offering mechanism where disclosure information already on the public file is incorporated by reference into the document, the issue of underwriter's liability becomes very important. In the SEC proposals, their consolidation of the short form with the public file did not in any way propose to change underwriter's liability. In other words, the underwriter would still have the same liability, not only for the statements in the offering circular, but for all of the statements on the public file, including the annual report, proxy statement, material change reports, and press releases that were incorporated by reference, as to which many of those documents, of course, the underwriter may not have been involved. The Quebec proposal, as it now stands, provides that the underwriter would not be liable for the documents incorporated by reference. This raises another fundamental issue as to the role of the underwriter in respect of the offering itself, and that I think is a very key question. Jim, do you see this kind of a system being a problem for underwriters in connection with their role in filtering, if you will, the information upon which an investor makes a decision, and or B, having a liability in respect of documents that are only incorporated by reference?
Theoretically, I would say yes. I think practically speaking, the answer to that would be no, though, Gar, on the basis that if we know what the rules are, we can play by the rules. If you ask me which set I'd rather play by, I'd rather play by the ones that limit my liability. But if we went the Ontario route, I think what you would find is that we would have to be more involved in material change reports that are being filed by issuers, in the quarterly statements and things like that. But I see no difference in the fundamental bottom line towards satisfying that obligation on a material change report or a semi-annual report than I would in, say, satisfying that same liability in terms of a prospectus. I just add the further comment in relation to this whole question that, and it's coincidental because as of this morning I have written the Chairman of the Ontario Securities Commission on the very point. In his report for the year, he made the point that we did something, and I don't have the numbers exactly at hand, of about $3.5 billion of Peter Day's equity-oriented instruments as public financing. I think one of the reasons for that, and that was prospectus and 4 to 5 week waiting period, is that the Canadian capital market is the basic provider of equity capital, and while some cross-border deals have been done and the odd issue in Europe, those markets are not deep in terms of providing equity capital for Canadian corporations. We only did $1.1 billion of debt, and the point was made by the director, Bob Steen, that high interest rates were a factor, and sure they were. But I think we did about $6 billion worth of debt in Europe. And the reason, in significant part, was the fact that if you wanted to go to Europe, and it's Friday morning, tomorrow morning, you could have an issue in the European capital market on Monday morning at 9 o'clock their time, and you're still asleep here. Timeliness. What's going to happen in this system, I submit, is that the credits that will go to Europe are going to be the large, well-known Canadian companies and provinces. So that you have your Imperial Oils and your Canadian Utilities and your Bell Canadas and your province of Ontario's going to Europe, and you're going to have other lesser credits that aren't known over there being forced to come in Canada. So it seems to me it's a little bit like Gresham's Law. We're going to drive out all the good credits. And I don't think that's what the intent of our system is.
All right. Obviously, that was a point that was only well made. It left everybody nonplussed.
Certainly the chairman.
We thought another area that would be of some interest to you, because it's an area of tension from time to time, and certainly developing policy from time to time, but it's an area in respect of which there hasn't been a lot of commentary, certainly no written commentary, although I must qualify that by saying that there have been a number of submissions that have been presented to the Commission in the area. And the area is the relationship between the securities commissions in Canada and the self-regulatory organizations such as the Toronto Stock Exchange, Montreal Stock Exchange, the stock exchanges. And we have on the panel a gentleman who, as I said earlier, has represented the Toronto Stock Exchange in a number of particularly interesting and innovative areas, and who is familiar with the dynamic tension, if that's the word that Charles Atlas used to use, that may exist from time to time as the perceived regulatory gaps get filled. David Jackson.
Thank you, Gordon. The tensions have certainly been dynamic. I'm going to talk a little bit about the self-regulatory process as it applies particularly in the Ontario model. Let me start at the beginning by mentioning that a similar relationship exists in other provinces, but the dynamism hasn't quite developed to the same extent in some of the other provinces as it has between the Toronto Stock Exchange and the Investment Dealers Association on the one hand and the Ontario Securities Commission on the other. In Ontario, the two primary self-regulatory bodies with respect to the securities industry are the Toronto Stock Exchange and the Investment Dealers Association, more accurately the Ontario District of the Investment Dealers Association, but for all practical purposes the IDA. The stock exchanges, both the TSE and other exchanges around the world, have traditionally exercised a kind of a self-regulatory function. The TSE was formed in 1852, and it predates Ontario securities legislation by 60-some years and predates the Ontario Securities Commission by longer than that. So from a self-regulatory point of view, the Toronto Stock Exchange and other exchanges have done that for some time. There are two basic kinds of self-regulation that bodies like the TSE carry out. The first is a credit and anti-fraud kind of self-regulation, and the second concerns what I might delicately call inappropriate competition among members. The credit and anti-fraud provisions, I think, are fairly easily understood. The reason for self-regulation in the credit area is that to make the stock exchange work, each member has to be able to depend completely upon the credit of the other members of the exchange for purposes of clearing of transactions. So with that in mind, the exchanges have developed what are referred to as credit rules and a net-free capital requirement of a certain amount of money after all the liabilities of member firms have been deducted. This is monitored on a regular basis by the exchange's staff, examiners, and the exchange has a panel of auditors who carry out that function. And so there's a process continually of monitoring the financial condition and positions of member firms. The second area that I refer to is the anti-fraud regulation by the stock exchange of its members. And that is primarily concerned with what Jim Pitblado referred to as the Know Your Client rules, except this time it's not in the context of the issuer as client, it's the public as client. And the exchange developed some time ago a series of rules which are intended to ensure that brokers have some familiarity with their clients and some degree of knowledge about the investment objectives and resources of clients so that they don't sell them. For instance, they don't sell the little old lady in tennis shoes that's continually referred to 100 shares of Underground Airways. The third area of self-regulation is the inappropriate, as I said, the inappropriate competitive conduct area, and that is really intended to ensure that member firms don't act in a fashion which is either unbecoming of a member of the exchange or in a fashion which jeopardizes the position of the clients or the financial community. And therefore, there are a number of conduct rules that are imposed by the exchange on its members with a view to ensuring that inappropriate conduct doesn't occur. Some of those can be construed to be anti-competitive. In the UK, the Mergers and Monopolies Commission is currently reviewing the practices and requirements imposed by the Stock Exchange London on its members from an anti-competitive point of view. In addition to the points that I've made with regard to self-regulation, the TSE, like all other stock exchanges, imposes certain rules with regards to the actual trading activity on the floor. and certain standards and obligations that are imposed on listed companies, and I'll come back and deal with those briefly in a few moments. Lastly, as a major participant in the Canadian capital markets, both the TSE and the IDA have been involved in areas both of regulatory reform and capital formation. For example, the TSE was perhaps the most active and vocal proponent of the now notorious follow-up offer obligation contained in Section 91 of the Ontario Securities Act. With respect to the capital formation process, the TSE and the IDA, and to some extent the Montreal Stock Exchange, have regular seances with the officials of the Department of Finance in Ottawa. You can judge for yourself the effectiveness of those. And the TSE, a couple of years ago, put in a major brief on pension reform in Ontario, which I think has been very useful to the Royal Commission that was appointed on pensions. As I've said, the IDA performs somewhat the same kind of function in the Canadian capital markets as does the TSE. I've referred to the stock exchange at greater length because the exchange, in most of the regulatory areas, has been the leader and has developed the larger resources. The area that the IDA is particularly active in is debt securities markets, and underwriting those ends of the securities business particularly fall into the IDA's purview. I should note, as is apparent to any student of the self-regulatory process, that there are both advantages and disadvantages to a self-regulatory system. On the whole, I believe that the advantages outweigh the problems. That view seems to be shared by the Ontario Securities Commission and the current government of Ontario, both of whom have continually referred to increasing the level of self-regulation and responsibility of the private sector as a part of the regulation of securities in Ontario. Although, on the other hand, I should mention that it has happened, this may come as a surprise to you, that some securities firms that are members of the stock exchange and which are the subject of a disciplinary action by the exchange as it performs that self-regulatory function have made unkind remarks about the sources of the salaries of the stock exchange officials and rude suggestions as to how they might better use their talents to the benefits of the industry than prosecuting that particular broker. In addition to the TSE and the IDA, in Ontario there's a third self-regulatory body, the Broker-Dealers Association, that regulates the activities of a rather small number of firms which trade primarily in the unlisted market. It performs some self-regulatory functions, but it's a long way behind the IDA and the TSE in that respect. Finally, on the self-regulatory organization front, there are several non-security self-regulators which have important roles to play in the self-regulation and the operation of the securities markets. Three professions in particular play an important part in the capital process, the capital market developments, and each has its own self-regulatory body. I'm referring specifically to the Law Society of Upper Canada, which regulates the conduct of members of our profession, the Institute of Chartered Accountants of Ontario and its big brother, the CICA, and the Professional Engineers Associations and Societies. While those three professional societies do not have direct relationships with the Ontario Securities Commission or with the self-regulatory bodies like the exchange, they are nonetheless important in ensuring the integrity of the whole process. The relationship between the self-regulatory bodies and the OSC is established in part through the Securities Act. However, part of what is in that statute is in fact fiction, and an important part of the operating relationship, particularly between the stock exchange and the OSC, doesn't receive any mention in the Securities Act at all. First, the fiction. Simply put, the Act indicates that the Ontario Securities Commission regulates all of the brokers, all of the registrants, all of the salesmen in Ontario. The fact is that in almost every respect, the OSC leaves the regulation of those members of the self-regulatory bodies, the IDA or the exchange in particular, to the IDA and the exchange. I submit that that's quite an appropriate approach to regulation in Ontario for at least three reasons. Firstly, the exchange in particular has substantially greater resources than are available to the Securities Commission. Secondly, the self-regulatory organizations have greater knowledge of the conditions and of the actual practices and activities of the firms and the brokers. Thirdly, an enlightened self-interest of the well-functioning self-regulatory organization will ensure that the problem will be dealt with effectively and appropriately. And I think that that's been proven to be the case in most cases in Ontario. With respect to the last of those items, the enlightened self-interest, it's been said about self-regulation that it is sensible to believe in it and it's appropriate to rely on it, but one should keep a well-oiled shotgun standing in the corner just in case. In Ontario, for the TSE, that shotgun is found in Part 9 of the Ontario Securities Act. You'll see that Part 9 is very short. It's one of the shortest parts of the Act, just 3 sections. The first, one of the 3 sections, Section 23, is really irrelevant to these discussions. It's simply a record-keeping obligation. But there are 3 substantive and important points from the self-regulatory point of view found in Part 9, in particular in Sections 21 and 22. Those 3 substantive points, in my view, provide not only the shotgun, but the shells and the lubricant. And lately, as Gordon has pointed out, the OSC has been making sure that the lubricant has been very well distributed around the gun. Those having any interest in the origins of Part 9 will find interesting reading in the report of Mr. Justice Kelly on the Windfall Oil and Mines scandal of the mid-60s. His Lordship was critical of some of the actions of the TSE in imposing its regulations and observed that the TSE was not subject to oversight by the OSC. There was no Part 9 in Viola McMillan's day. He recommended that the TSE be brought under the control of the OSC, and so the predecessor of Part 9 was included in the 1966 revision, the 1966 Securities Act. The first principle of the 3 that I think are important is found in Section 21, and that says that a stock exchange may not carry on business in Ontario unless it has been recognized in writing by the OSC. To my mind, that's a pretty substantial gun all by itself, although withdrawing recognition of what is currently the stock exchange that accounts for 87% of all Canadian trading in equities may be slightly draconian. As an aside of somewhat arguable humor, more than 5 years after that requirement came into effect in 1966, the OSC realized, I suspect to its horror, that in fact it hadn't recognized formally the TSE. It did so quickly, and OSC Policy 317 is the result. The second important principle is found in subsection 1 of Section 22 and can be referred to as the initial oversight provision. This lets the OSC make any decision that it believes to be in the public interest with respect to 4 broad topics. 1, the manner in which the stock exchange carries on business, and I submit that's pretty broad all by itself. 2, any bylaw, ruling, instruction, or regulation of the exchange. 3, trading on the exchange or in any security listed on the exchange. And 4, compliance by listed companies with any requirement of the Securities Act. That oversight relationship has led to the development of a practice which is, to me, most extraordinary. The TSE acts primarily by bylaw. Most of its rules are found in a thing called the General Bylaw, which is amended regularly. However, the Securities Act does not provide that the OSC must approve TSE bylaws before they become effective. Because the OSC can make any decision it thinks appropriate with respect to any TSE bylaw, the exchange has developed the practice of enacting a bylaw and floating it up to the OSC to see whether the Commission will object, a sort of a let's run it up the flagpole and see who salutes kind of approach. Or in the words of the wonderful explanation of a straw vote, this isn't a vote, but if it was a vote, how would you vote? If the bylaw passes, the Commission indicates that it does not disapprove, to put it in double negatives, of the bylaw, and it then becomes effective. That can be contrasted with the provisions in the British Columbia Securities Act, which requires the express approval of the Superintendent of Brokers before a bylaw of the Vancouver Stock Exchange becomes effective. Although there have been many examples of the OSC deciding that it should examine a requirement of a proposed or an existing bylaw, perhaps the longest-running major musical has been the question of fixed commission rates. Hearings have been held in 1966, 1973, 1974, 1975, 1976, 1977, and 1981. And Those questions have either looked at, those hearings rather, have either looked at the question of whether the stock exchange should be permitted to continue to set its own rates, or whether it, if it should, whether the rates in question are appropriate. You may recall that in 1975, the SEC ordered the stock exchanges in the United States to go unfixed. That question has been under debate here since. The third area of oversight by the OSC, found in the second part of Section 22, is the appeals provision. That permits the party aggrieved by an OSC, by TSE rather, decision to appeal that decision to the Ontario Securities Commission, and the Commission can make any decision or determination that it thinks proper and appropriate. There have been some interesting examples of how that appeal provision has been used. Areas of membership, including the long-running application by Lafferty Harwood of Montreal to join the TSE, Baker Weeks, a U.S. non-resident ownership question, and the recent hearings involving the acquisition in the States of Beche by the American Express. The application of certain rules by the exchange has also been the subject of appeal. Takeover bids, particularly, as Gordon has mentioned, Olympia and York's bid for Abitibi Price was a matter of a series of hearings with respect to the application of the stock exchange's takeover bid rules. And Cofield Brown, which has turned into a minor saga of its own, with regard to the question of the issuance of an option and TSE approval of that option. The test that's been adopted by the Securities Commission and by the courts with regard to appeals from the stock exchange's decision basically is, has there been an error of law or a denial of natural justice, or is there some new and compelling evidence that wasn't before the tribunal that made the decision initially? That test has been followed by the courts, in particular the Divisional Court and the Court of Appeal in the Lafferty Harwood cases enunciated or articulated that approach. There have been some interesting and active areas where the TSE has gotten itself involved in a quasi-legislative function. One is the area of takeover bids that Gordon's referred to. The exchange offers an alternative to the circular for the acquisition of listed companies. One advantage is speed, although it's not substantial, but it offers effectively the only national approach to takeover bids, and we've got provinces going in different directions with regard to takeover bids currently, takeover bid legislation. The stock exchange provides some degree of consistency. The last areas I'd like to touch on are with regard to timely disclosure obligations and other activities in which the Stock Exchange and the Securities Commission together regulate actions by issuers or listed companies. Timely disclosure, it's usual to notify both the exchange and the Commission with regard to changes that are material. Where an issuer which has listed securities intends to list additional securities, there is an obligation to obtain OSC or TSE approval. Those decisions have on occasion been appealed to the Securities Commission. Generally speaking, the OSC has left to the stock exchange the regulation of its own market. An interesting departure from that has occurred in the Turbo Banquino Merlin transaction, in which the exchange and the Securities Commission have differed publicly through press releases on the question of what constitutes market stabilization. The last area where there's an interface between the exchange and the Commission is in the area of regulation of statements of material facts, where the exchange processes them with the Commission looking over its shoulder. That process has led to a kind of a mini prospectus review process, an attempt to avoid the situation which occurred during the development of the South Sea bubble in the UK, where people were invited to subscribe for shares of a company to be carried out, to be formed to carry out an activity of great profit and advantage to its security holders, but nobody to know what it was. Thank you, Gordon.
Thanks, David.